Hey, hello everyone. Good afternoon. This is Nina Olson from the Center for Taxpayer Rights. And this is our tax chat number 6 in our series on transforming tax administration. And as I keep saying to everyone, this is AI week or big data week or something like that, because this is part 1 of a discussion about the use of big data, artificial intelligence, machine learning, automated decision-making in tax administration, and some of the things that we need to think about this as we are moving into this bright and brave new world. We have some incredible guests today, and I'm going to introduce them in the order in which they're going to start off speaking, but I do want to note that this is being recorded. And also, if you have comments or questions that you want to make, you can put them in the chat. I'll be monitoring the chat, and we can try to incorporate them as we go along. So the first person who's just going to open our conversation is Jay McTigue, and he is from the Government Accountability Office, and he's a director in the Strategic Issues team. And I've known Jay for a long time, and I've just really admired his work and the recommendations that they make. And so I think you're really going to enjoy some of the, and learn from some of the things that he's going to talk about. The next person who's going to talk is Dan Ho, and Dan is from the Stanford University Institute for Human-Centered Artificial Intelligence, and he's the director of the Regulation, Evaluation, and Governance Lab. And the other thing is that Dan has done a lot of work advising the Administrative Conference on the United States on issues relating to artificial intelligence. And he is also one of the co-authors of the recent study that found racial disparity in the IRS's audit selection model. And Dan will talk about all of that work on this call. Then our next speaker or chatter will be Don Fort. And Don is the former chief of criminal investigation at the IRS, and he's now director of investigations at Castellanets and Fink. And I've known Don for quite a while too, and I was always really impressed with his work as the chief of CI. And under Don, the IRS really made some important movements into cybersecurity and trying to use data and artificial intelligence. And I think that Don's insights into where the IRS is and its capacity and some of the challenges that it's facing will be really, really informative. And by the way, both Don and Dan testified before the Senate, before 2 separate committees on May 16th. And we will put links to various reports from the Government Accountability Office and Dan and Don's testimony as we build our webpage on this series. Our last speaker is Filippo Noseda.
Right.
Okay, I've got it. And I asked him to join us because last week, breaking news, the Belgian Data Protection Authority ruled that the Belgian tax agency cannot send information under an information exchange agreement per FATCA, the Foreign Account Tax Compliance Act, to the IRS. The information that is for what we call the accidental citizens, who are Belgian citizens, but are also US citizens. And under the information sharing agreement, there was information going over. And I've asked Filippo to really talk us through that and give us a little bit of grounding in the GDPR, the General Data Protection Act, so that we have some understanding of some of the protections over in Europe that the United States has not even begun to address. So with that introduction, I'm going to hand it over to Jay. So Jay, just say what you want to say.
All right. Well, thank you, Nina. It's great to participate in another one of your wonderful tax chats. Always very informative and great panelists. full disclosure, I'm not an AI expert. So over this weekend, as I was thinking about what the heck I was going to talk about today, I actually Googled big data. What is meant by big data? Because I have been auditing IRS now for more than a decade, and in my mind, if anything qualifies as big data, it's the IRS. Annually 150 million tax returns, but on top of that, we did a study back in December 2020 looking at information returns, which are forms and reports that employers, banks, and many other entities send to both taxpayers and the IRS. And, right now, IRS collects about, 4 billion information returns. So on top of the 150 tax returns, with hundreds and thousands of data points, you have information returns, 4 billion. We identified 50 different types. Some are still actually submitted on paper, unfortunately, but that is a lot of data. Where I think IRS differs from, the accepted definition of big data is, its lack of systems, skills, and ability to really leverage those data with modern information technology systems. As we heard in one of the prior tax chats, IRS is still using systems that were developed 60, 70 years ago that use assembly language and other very old languages, and a lot of the processing is sequential as opposed to parallel processing and all the new technology that makes artificial intelligence and machine learning possible. But again, going back to the report that I mentioned that we did on information returns, we found a number of the issues that I just mentioned, that IRS has limitations in its ability to use those data, given the age of its systems, the incompatibility of different systems. So systems don't talk to each other. They're database, and as a result, databases that are accumulated in different divisions or offices that are at IRS are not easily shared and leveraged. We also found, as I mentioned, of the 3 to 4 billion information returns that come in, about 1% is still on paper. Doesn't sound like a lot, but that's 30 to 40 million forms that come in on paper. And a couple of years ago during the pandemic, IRS had a huge backlog and ultimately ended up tossing some of that information, and that caused a lot of consternation across town here. And so what does this all mean? As I said, in order for IRS to even begin to think about using machine learning, artificial technology, it's really imperative to invest both in the technology, the skills, the people to make it all happen. And prior to our work on information returns, we back in, let's see, I think it was 2019, did a report on FATCA, which we'll be hearing a little bit more about later on. And we found some of the same issues. IRS was collecting or receiving a lot of this information, but was having trouble matching the information, for various reasons, including, the foreign financial institutions not reporting TINs, and again, just IRS's ability, the flexibility of their systems or inflexibility of their systems to really leverage the data that they had, the information there. The two themes, or one theme that we saw across both of the reports, was a lack of a comprehensive approach or strategy. I hesitate, using that word strategy because we always hear about the need for a strategy. But in this case, I think it's really important that, IRS step back from the individual information reports that I described, the 50 different types, and, take a broad look and, see how they could best use that information, make connections across divisions and offices and, the forms, frankly, to, again, better utilize what's there. And, frankly, that's what big data is all about, and machine learning, or, one type of artificial intelligence, at least. IRS has not yet acted on that recommendation. We made a similar recommendation in regard to the FATCA data to really, step back and come up with a strategy to address some of the issues. And IRS has made some progress in the FATCA arena, but still could do more. And then finally, I'd like to just again, I'm not an AI expert, but in 2021, about 2 years ago, GAO did issue a accountability framework for use of AI in federal agencies. And our objective really was to identify key practices to ensure accountability and responsible AI use in the federal government. The framework itself is organized around what I call 4 pillars. The first is governance, and perhaps the most important. And under that, we talk about establishing structures that promote accountability and responsible use of AI systems to process, manage, operate, and oversee the implementation of such systems. We have a pillar on data, and I think we'll hear more about this. And that's the ensure that data are appropriate for each intended use in a system, and to the extent possible, ensure that data are of high quality, reliable, and representative. The third pillar, performance, we talk about ensuring AI systems produce results that are consistent with program objectives and that systems meet their intended purposes. And again, that's an issue that has come up recently. And then finally, we think it's very important to ensure the reliability and relevance of each AI system over time. And the key practices here include monitoring performance and assessing the sustainability in any expanded use of an AI system. I guess in closing, I would just say that clearly AI presents a lot of opportunities for the IRS, but it also presents expanded oversight challenges, because a lot of what's going on is not readily observable. The skill sets that are needed, not only to implement, but to oversee are, a little scarce in the federal government. So I'll stop there. And I think, is it Dan who's going next?
Yeah, I have a few, looking at the reports, one thing that really popped out about the FATCA report, which was something that, we had, as the National Taxpayer Advocate, had reported on and recommended Congress fix, and you all had done this, was that 75% of the reports that came in basically involved duplicate matching. You had the taxpayers reporting information on these accounts to the IRS, and then there's a separate, reporting requirement to Treasury. And we all recommended that, and I recommended it administratively, why don't you combine these fields? And what was happening was taxpayers were being penalized because they had not reported the exact same information on each of those forms, even though they had reported it on one form. And you just thought that kind of penalty really drives people crazy and is just unsupportable. It's hard to defend. And yet the agency was like, well, this statute is under Treasury and this is ours, and we don't have the authority to change their forms. And we could never get Congress to pay attention to do the legislative fix if that's what was required, so that you could have a combined form. I don't know what your experience, what your conversations were about that.
Very much the same. Taxpayers, especially those overseas, are very frustrated with having to report twice. There's a lot of confusion, and it's a significant burden as well. We at GAO did make a recommendation to Congress to revisit the statutes and simplify the reporting. A lot of the information is the same. The thresholds are different. The information is used for different purposes, but it's all going to Treasury. Some of it's going to IRS, some of it's going to FinCEN. Treasury should be able to manage that, protect the data and use it appropriately. It's not a heavy lift. We're still advocating for that matter to be implemented.
And again, I think the concern is the penalties that when the government, somewhere in the government, they have the data and yet you're penalizing people for not providing it in the correct format. That becomes a real taxpayer morale, taxpayer rights issue. The other thing I noted, and I'll just comment on, is that right about the time that the information exchange agreements were really going into effect, the IRS closed the 4 remaining tax attaché offices abroad, in Europe, in China, and et cetera. And my office was like, why are you doing that, as you're imposing obligations and taxpayers needing to get Social Security numbers that they never knew that they needed to have, and there's no vehicle and you have no toll-free phone line into the IRS from abroad. You have to do mail. The answer was, well, it costs money, and it turned out to be about $4 million. And I actually offered to give them $4 million of my budget to keep those offices open, but they didn't. And I'll just put this little plug in GAO's ear that the other thing that we offered was that perhaps that there should be a local taxpayer advocate established for at least each continent, so that somewhere in the continent there was an office that was dedicated to dealing with the problems that the US taxpayers had in navigating the IRS, requirements. So with that, I'll turn to Dan. I just wanted to get my in there somehow.
Well, thanks, Nina, for the invitation to be able to speak with such an esteemed panel. And thanks, Jay, for those really thought-provoking opening remarks. I thought I would start by maybe drawing a little bit of a connection here, which is that, as Jay noted, the GAO accountability framework, I think, has been really important to think about how to move the federal government to both be able to modernize and take advantage of the incredible advances that we're seeing in artificial intelligence, but also have the kinds of governance and monitoring systems in place that are so sorely needed with the rise of this technology. So GAO was first out of the gate, and then you saw a series of other government documents, including Executive Order 13960 on the AI use in government. NIST released the AI risk management framework, and the Administrative Conference of the United States also issued a set of statements and recommendations about the use of AI. So the opportunities here are really quite broad and promising. But my own assessment, coming from some research that we did, is that the federal government is not yet ready, in huge part because of the sort of data and digital infrastructure and technical talent that Jay mentioned in his opening remarks. When we did a study of the implementation of existing legal requirements placed on federal agencies, the implementation was really pretty inconsistent, including things like filing an AI use case inventory that enumerates where AI is being used. 88% of federal agencies did not sort of respond to the requirement to identify regulatory authorities that pertain to AI. And the Office of Personnel Management is long overdue to provide a report on forecasting the AI employment needs and creating an AI hiring line. And so that really leads me to kind of 4 points I want to make just to kick off this discussion. The first is, I will use the word strategy in contrast to Jay. I do think that a strategy for how to take the IRA money and actually modernize IRS's systems and leadership are really going to be necessary to make sure that the IRA funding isn't just used to sort of step up the volume of enforcement without actually being able to learn from the data that Jay nicely noted IRS already possesses. The second is just how important it will be to bring in technical talent into the agency. The Stanford Human-Centered AI Institute put out the AI Index, and the AI Index notes that out of the recent graduates who receive PhDs in AI, about 60% go into industry, about 20% go into the academy to teach, and less than 2% are in federal government. And that is going to make it extremely hard for an agency like the IRS really to be at the cutting edge if we cannot recruit the top technical talent into the agency. That's why things like the AI Training Act and sort of Office of Management and Budget guidance is really critical here, because to the extent that you actually end up procuring these kinds of systems, you still need to have the requisite talent to be able to manage the acquisition and oversight of contractors who are building out these kinds of systems. Third, on the digital infrastructure side, I think it's really important to think about mechanisms of oversight and responsible AI that really work for this technology. I'll give you kind of two examples. One is that at a lot of agencies, securing the authority to operate for kind of modern machine learning frameworks is a real a challenge. And that means that federal agencies can be decades behind in terms of the software stack. And that actually poses real risk in terms of the kinds of tools that are being used. And then the second, as Nina alluded to in our opening remarks, is that we oftentimes don't really understand even how existing legacy systems work. And that is, in a sense, why our research team spent quite some time figuring out how to implement something like Executive Order 13985, which is the racial justice EO, that requires agencies to monitor disparities across different demographic groups, and is really what led us to kind of uncover the racial disparities in the report that Nina had mentioned. Maybe the last thing I'll just say is that the AI transition, in my view, is often incorrectly thought to sort of replace human discretion, and I actually think that's the wrong way of thinking about it. I think we really need to be thinking about AI systems that can augment the capacity of the federal workforce to do their jobs in more effective and responsible ways. So that's what I had just to kick off the conversation, and I think with that, I'll turn it over to Don.
Yeah, you know, I think this, and Don, you will probably want to comment on this. I think that one of the things that I saw in Dan's, you know, discussion and some of the reports that he mentioned, that OPM report that where they were supposed to, Office of Personnel Management was supposed to create an artificial intelligence occupational series. And we both know how hard it is to get a position description developed in the Internal Revenue Service and then approved by OPM. But here you have a statute that's saying, do this, and they've missed the deadline by almost a year. So maybe you can also address your experience of trying to hire folks in those skill areas as chief of CI. But
yeah, of course. And really enjoy those. The Jay and Dan's comments definitely have a couple of experiences that I can share, but thank you, Nina, for the invitation. So also, Nina and I worked at the IRS for many years together, and I was chief of CI. I also had a tremendous amount of respect for the work that Nina did and continues to do. So thank you for that. So just a little, background on myself. So I retired at the end of 2020. And so I was a chief of CI in my last 3 years. I actually spent all like 30 years of my career on the criminal side of IRS, but worked really closely with other executives and the commissioner and the deputy commissioners at IRS And really in my last 3 years did a lot of work or really tried to do a lot of work and advance a lot of work in data analytics. And a lot of that work was, it was dealing with other sections of the IRS using models and algorithms to look at just the internal data that IRS has. And Jay made the point of just the sheer volume of records, like B with a, billions with a B. It is an astronomical amount, and I would always contend that the IRS may not have the most data of any U.S. agency, but I think the richest financial data, in terms of being able to potentially mine, and really the key word that Jay mentioned is leveraging, right? It's leveraging the information that's out there to try to best deploy the resources. Limited resources, where do you deploy those expensive human resources to do audits and investigations? So we did a pilot that built a model and algorithm really looking at payroll tax fraud, really on the most extreme end, that there was potential criminal violations. And with the help of some really smart people and some technology, we were able to successfully build that out and identify some really significant payroll tax fraud cases. And I'll note again that was just by using internal data. So those information returns, the millions and hundreds of millions of tax return filings. What it didn't include was external data. What's available, open source, publicly available. And when you're only using internal information, it only tells part of the story. There's so many businesses and individuals now that are making significant sums of money and operating exclusively, no brick and mortar anymore, but exclusively out on the internet. So I would say, like, my experience was the IRS, and I include myself in this, so I'm not poking the IRS in the eye. This is and was woefully underutilizing data. But the reason for that, this is not like a unique idea. This is really a lack of funding and a lack of manpower and a lack of talent in some of those, the fields that Dan mentioned, that, without that, they know what they need to do, but there's really no budget. So when it would come time to, try to invest and try to make some headway in data analytics, keep in mind that the pilot that we did and some of the work we were trying to do broader at the IRS was with essentially no money, no budget whatsoever. So cobble together and do the best. So I think that, with the IRA funding, that there is more of a strategy. And again, I can say from being there, we tried to have a strategy, but the lack of manpower, the lack of budget, the fact that so much of the money goes into keeping those 60-year-old systems, tied together with bubble gum, basically, means there was no money left over for anything else. So again, it's not for a lack of trying or not for a lack of understanding what they need to do. They're just really constrained by those, the budget and the manpower. One of the points that I also wanted to make is on the issue, particularly as it pertains to AI, but I think it also, there's some overlap there with data analytics. As I mentioned, my work was all on the criminal side. And when you talk about the AI and data analytics, the point that I would always make and still make is the importance of human beings in that process, particularly on a criminal investigation where you're allowing technology to, cull through internal and external data and decide who's going to be under investigation is a very dangerous road, to head down. And I think it's really the goal, particularly on the criminal side, but I also think it relates to the civil side, and would be curious on others' thoughts. It's great for, leveraging the information that's out there and maybe pointing investigators and auditors to where the non-compliance may be. But at the end of the day, you need a human being, particularly when you're talking about putting somebody under federal investigation and the weight that carries with it. You really need some checks and balances and some human beings there at the end. So, the couple other points I want to make, Nina, it's interesting you talk about the attaches, because I also find it interesting, I've traveled around the world, and now CI has 30 some attaches around the world. Unfortunately, they're not in a position to help, US taxpayers living abroad. But I think it is interesting that there's still nobody that's there to help US taxpayers. I can't tell you how many times somebody, an ambassador or the deputy chief of mission would ask me when I was there, hey, I've got these civil questions from folks that are living here. Can you help me out? So I think it, demonstrates that certainly that there's an issue there. On the talent question that I think each of the speakers have alluded to, when we were starting down this road and having some success around the data analytics, the commissioner gave us the authorization to hire data scientists and those in the data analytics profession. The problem was, if you go back 3 or 4 years ago, the job market was unbelievably strong, and unbelievably strong for individuals and young professionals in this field. So for the IRS, on the government scale at an entry-level position potentially, to be able to compete against tech firms was, it wasn't a level playing field. So we would announce jobs and we would get almost no applicants because there was nobody out there in the field. But so I agree it's necessary to get some people inside. I also think it's an opportunity, and the IRS and others have done this, is to, get some people inside, but also partner effectively, to partner with technology firms, private industry firms, and also academia. The work that Dan's doing and others, there's a lot of really, really smart people out there that want to help the IRS and government agencies tackle this data problem. And I think that's a real opportunity. And I think it's a balance there between, you got to have some people inside the building, but also leverage the really smart people that are working outside the building. So I think I'll pause there and kick it back to Nina.
Well, thank you. And I think, your point about, you have to have a human being in the process, I think that goes to the issue that arose in the Netherlands that probably, Filippo, you can also talk about that with the child care subsidy and the system that was selecting individuals based on just a very simple misinformation or not updating information, and the agency feeling like they had no discretion to and no ability to apply proportional collection. And then the other case was the Siri case, maybe more to the point, SYRI, which was the system that basically resulted in referrals to the police and prosecutors based on about 17 different data sets that could be looked at, and an agency could come in saying, we're looking at a particular thing, tell us what you find. And the results would be transferred if someone was risk scored for a risk of fraud. The information would be sent to the police and the federal prosecutors, but no one could give an explanation to the individuals whose information was being sent and whose referrals were being sent. So there could be no explanation and no real opportunity to protest that. And that system was found to be a violation of the European Convention on Human Rights. So with that, maybe I'll turn it over to Filippo to sort of give us some background on this and then talk about the work that you were doing just in the area of FATCA.
Yeah, absolutely. If I may share the screen,
Yes.
I wanted to show you, thank you very much. I've been asked to talk to you about a decision that came out last week, taken by the Belgian Data Protection Authority, basically prohibiting transfers of FATCA data to the US on the basis that it violates basic provisions of the GDPR. The GDPR is the EU's General Data Protection Regulation. It was effectively introduced following the Snowden revelations in order to enhance the data protection rights of EU citizens. Now, rather than talking to you about abstract concept of EU law, which I'll do it in a minute because I need to do it in order to explain the significance of the decision. My role with FATCA goes back to 2016, first academically and then appearing before the EU authorities and the European Parliament talking about data protection, and currently representing a claimant before the High Court in London who is effectively querying the data protection implications of FATCA in her case. And along the way, we've amassed about 200 letters to the EU that you will see there on our website. If you Google mishcon.com, it will come out. And I just got a selection for you before going to the EU. That in 2021, the US discussed the idea of introducing a domestic version of FATCA. FATCA is effectively a central database of bank accounts. Now, in FATCA's case, the database is held by the tax authorities in the foreign countries, then exchanged with the US. And in 2021, Congress was thinking of introducing a domestic central database of bank accounts, and that didn't go down quite well. I got there a letter by members of Congress quoting previously concerns. There was then the industry. There's a letter here from the Independent Committee of Bankers of America talking about this. IRS data collection should be tied directly to tax liability and should be no broader than absolutely necessary. Now, that, without them knowing, is absolutely GDPR language. So we're going to come back to the GDPR in a second, but it's the same issue. So the concept of proportionality and necessity, the concept of relevance, there must be a tax liability, and another GDPR concept, which is data minimization, which is that data should not be processed unless it is absolutely necessary to achieve the objective. And since the GDPR came into effect, this concept of data minimization has been crucial in the EU for the development of the GDPR. There was also a letter by the American ABA going in the same direction. And then I'm sure that you've seen the Polselli judgment, which in the US sort of caused a lot of attention because it allows the IRS to access bank accounts without notice. But actually, the reverse is also important, which is that the IRS does not have an unfettered right to access any bank accounts. You need to have a tax delinquent, and there are other limitations. Whereas FATCA operates automatically without any indicia of tax evasion. So you can see that even before we come to the EU, in the US, privacy and FATCA are sort of relevant. And then, what you discussed earlier about, the 60-year-old systems and the fact that information, that the IRS is overwhelmed by data, it is an important factor for the necessity of the necessity test under the GDPR, because Congress thought in 2011-12 that FATCA would bring in $8.7 billion. In reality, it brought in $14 million, according to the Treasury report by the Inspector General for Tax Administration. And the report also shown that of the 30 million reports come in, about 1/3 are faulty. And the IRS effectively said, we're not really applying FATCA. We've departed from it because we can make sense of the information. So that's in the US. Let's come now to the decision. The GDPR, as I say, has got a number of principles which are here. So data minimization, purpose limitation, and lawfulness. And what the, amongst other things, and accuracy, for example, and storage limitation, and integrity and confidentiality. So one of the problems noted by the Dutch Data Protection Authority, and perhaps a bit of background on the decision, there's an association of accidental Americans who brought a GDPR complaint before the Belgian Data Protection authorities. I've helped out with amicus briefs in a number of similar claims in Belgium and in the Netherlands. And to our surprise, given that the EU hasn't really done anything in the area, last week the Belgian Data Protection Authority said that FATCA is effectively disproportionate because it does not require any indicia of tax evasion. It's just information for the sake of information. It is sort of discriminatory because if you got a bank account in the US, your information stays with the bank unless you have got a Pulselli kind of problem. And otherwise, if you got a bank account abroad, maybe because you live abroad, on the second floor of a building, and on the ground floor you got your bank, or you're an American that has to have a bank account abroad, you've got information just flowing, which may be inaccurate. And then you might have an audit by the IRS because of wrong numbers. And then you got, a knock at the door and expenses and all the rest of it. So there is a lack of proportionality. There's also concerns that have been raised ever since Snowden's report in the European Court of Justice, which is sort of the equivalent of the US Supreme Court, because the EU has struggled, twice has tried, and twice a young, used to be a young law student called Maximilian Schrems, an Austrian, went to the European Court of Justice, and twice the European Court of Justice said that once the information comes to the US, it is not subject to the same level of data confidentiality and protection as you would have here in Europe. And as you know, those of you who have been following the FATCA saga, there was a constitutional challenge in the US against FATCA, and the Supreme Court said there was no constitutional right to privacy in the US in information disclosed to banks, a decision from 1976, I forget the name now. And because of that, therefore, when information goes from the EU to the US, there must be specific standards of safeguards, and FATCA does not really contain any safeguards at all. If you look at it, it's effectively two macro systems coming to a head and colliding. There is no compromise really, because FATCA was developed, quite rightly as a reaction to excesses of the past. I'm Swiss by background. I'm an English solicitor, but you might get it from my accent. I'm not a native English speaker. And the Swiss banking system created FATCA because of the abuses of the past. You will remember the Levin report, Birkenfeld talking about diamond in toothpaste and all the rest of it. So FATCA was a reaction to that, and came also hot on the heels on the fight against terrorism following 9/11, where government felt that actually they had a right to collect metadata, because they felt that if you collect all the data possible, then we catch terrorists, and that was effectively applied to taxation as well. Now, with Snowden and with the awareness, and also in the US, the big fight about the FBI and Apple following the San Bernardino terrorist attack, the new focus on data privacy. So FATCA is effectively 2000 to 2010, and the 2010s 10 to 20 effectively has been the decade of privacy. And now in 2023, the two systems are colliding. And so you have this decision that certainly will be appealed by governments, but you have Jenny's case, which is the case that we represent before the High Court, that is going to come for a full hearing in November. And then you have other claims around, around the world, as I understand. And so we come now at an interesting intersection where we are talking about AI and what AI can do in the field of taxation. I fully understand that AI can revolutionize also the problems described by the person who spoke before me about, 60-year-old systems. AI can help with that, but how do you protect the privacy of citizens, especially when we've seen with ChatGPT that AI can make up information? So the GDPR, although in the US might be in some corners be seen as extraordinary, excessive, we know that there are also concerns in California and other states about ensuring that our data, which is effectively oil, on which big national tech make the money, effectively an asset that belongs to us and needs to be protected. Nina, this is really an overview. I didn't want to go into the details of GDPR Article 567, 52 of the Charter of Fundamental Rights of the EU, but happy to take questions, and otherwise I give back the floor to you, Nina. You're on mute.
Thank you. I think this is so fascinating. And in reading the opinion, I just thought, you showed it on the screen, but the Data Protection Authority notes that the generalized and undifferentiated transfer of tax data per FATCA does not respect the principle of purpose limitation. That is, the agreement does not contain exact objectives for the transfer of data, nor the principle of proportionality and data minimization, that is, only data strictly necessary for the purpose sought, in this case combating tax fraud, can be processed. So it wasn't like, it sort of tried to lay out a roadmap. It wasn't like, and that's what I thought was also so important about the Siri decision, was that the judge was saying there's a legitimate purpose in the government trying to combat fraud, but that has to be balanced with with the legitimate right to basically privacy and your personal affairs. And there are ways of doing that, but you have to acknowledge that you need to make that balance.
Absolutely that, Nina. And in fact, if you think about it, the 2000s, 2010 was the time where the objective was wonderfully articulated, also with the help of Paradise Papers, Panama Papers. So the purpose and the objective has been absolutely clearly articulated. We need to be able to fight tax evasion, and FATCA was introduced really to go and get US FATCAs hiding money in offshore accounts. That makes sense. But if, like Jenny, I am a researcher living in the east of England, living effectively 200 yards away from the bank, where is my offshore account? And plus, she earns less than $108,000 exemption for foreign earned income. So there's no tax at stake. So what the 2010s, 20s said, privacy, and now we need to do the balance. And what the courts are now doing is effectively striking the balance to say, it's all fine. It's not that we are against the fight against tax evasion, absolutely fine. But in the same way as a policeman who wants to enter my house in order to get, to check if I harbor a fugitive, needs to have a warrant. And look at Pulselli, in certain circumstances, yes, no, immediate danger. But normally, the police, with all the goodwill, they need to have a warrant because I have my right to privacy. And it's in Europe, that principle, it's sort of fundamental importance, because before the GDPR, it was enshrined in the European Convention of Human Rights, Article 8, that says that everyone has got a right to respect for private life and correspondence. And that 1950, it was 5 years after the Holocaust. And it was when, Stalin died in 1953. And so here was Western Europe saying effectively to the other people surrounding Western Europe that we have to have the citizens at the center of the political architecture. The state, of course, needs to be able to function, but there needs to be a balance. And when looking at the balance between state and individual, sorry if I become philosophical, Nina, the individual's right are fundamental, and the state's ability to function around individual is sort of the exception. And that, interesting, in Europe, was reiterated in 2000 when the EU, after the Berlin Wall came down and just before the Eastern Bloc joined the EU retook this fundamental right under Article 8 of the Convention and put it in 3 articles of a EU Charter of Fundamental Rights. Article 7 is effectively privacy. Article 8 was data protection, because of course, since 1950, we had the internet evolving, taking really foot in 1996. So you got data protection. Article 52 says we need to talk about strict necessity. And the European Court of Justice thus far has been a bit like the US Supreme Court, really looking at the letter of the law and says, we don't care about politics. If it is not necessary, if it doesn't fit, you must acquit. You need to find another way to achieve your objective without trampling over the rights of individuals. And in Europe, where we have populism, where we have a number of EU member states, in open proceedings because of problems with the rule of law, with the proximity to Russia, the courts are really reacting and say, please do the balancing act. The problem for the IRS, the problem for the UK tax authorities, the HMRC, are that they are still fighting their fight based on the narrative that if you're against FATCA, it must mean that you are in favor of tax evasion. And they, I think they've been left behind. And this decision shows exactly the path is what you said. There is a fundamental right for tax authorities to collect tax, but there is a fundamental right of individuals to ensure that there is not indiscriminate exchange of information that way. And from FATCA came, of course, the CRS. We know that the US is not part of the Common Reporting Standard, but the problem of the CRS is that you have exchange of information with countries that have got no taxation. So we exchange information with Saudi Arabia. How can that purpose limitation, how can that be for the purpose of fighting tax evasion where there can be no tax evasion where there is no taxation? We exchange information with despotic countries. I'll stop there, but I think that the decision by the Belgian authority is a watershed in our campaign.
Well, I think
I actually wanted to, Nina, can I chime in there? Because I
yeah,
actually
absolutely.
wanted to reinforce a couple of points that Filippo made with some real life examples. And you mentioned that I testified a couple of weeks ago. The first question that Senator Wyden asked me was about FATCA. And he pointed to 7 criminal cases since the enactment of FATCA, and his question had more to do with if the IRS had more resources, could they do more? Which I delicately sidestepped, but you would expect IRS CI as one of the most aggressive in investigating, tax evasion around the world, UBS, Swiss banks, just like Filippo mentioned, that they would be one of the primary users of this data, and it would be a wealth of information for potential tax evasion cases. The stats, it's not a direct, apples to apples comparison, because there are other cases that involve FATCA, just not directly from a FATCA filing. But I can tell you from being there that was not a huge source of information to either supplement or, point to potential areas of non-compliance. So it just, and that may have been more that the data just wasn't, even though it's potentially useful data, wasn't in a format that it was really useful for, trying to find non-compliance, but just wanted to kind of reinforce a couple of those points.
thank you.
Can I chime in there? Oh,
Yes,
sorry.
absolutely, Dan. And I was going to turn it over to you to talk about, another point that Filippo made, which was sort of the quality, and Don too, the quality of the data, and then what that does with it. But go right ahead.
Yeah, no, I think this raises such interesting and important issues when you think about, a principle of data minimization and how that would work in something like the IRS context. I think one thing that's really important to remember is that the American privacy system is really bifurcated. We have a very balkanized system when it comes to the private sector with very sector-specific laws. And then Congress in 1974 decided to act really with respect to government agencies when it implemented the Privacy Act of 1974. And so what we have is really, in a sense, a 50-year-old experiment on data minimization that exists within the federal government, and virtually no bounds where, for a lot of private sort of large tech companies that are out there. And I think that actually connects to a number of the points that have been raised so far. For instance, number one, Nina, the 75% duplicate reports that you're mentioning and the difficulty of sharing between IRS and Treasury, that's as a result of the data minimization principle, that gets applied because you can't easily link records, because the whole kind of premise of the 1974 Act was animated by Watergate and the federal government creating a unified system of records. It relates obviously, Filippo, to what you mentioned here in terms of like bank information reporting. And third, it actually also has been one of the biggest challenges to doing disparity assessments within government. So in their equity action plans, 21 of 25 agencies that reported out their equity action plans in response to EO 13985, which requires equity impact assessments. 21 of the 25 mention really serious data challenges because they do not collect information about race and ethnicity and can't easily link to census records because of the constraints of the Privacy Act of 1974. So I think it really raises some very challenging issues of how to draw these kinds of trade-offs. The last thing I'll just say on that front is that this also implicates when IRS works with third parties, because to the extent that third parties are not as constrained as government agencies are under the Privacy Act to kind of link different forms of records, we have to have really important standards there to make sure that that does not become a kind of backdoor and end run around the Privacy Act of 1974. That's, of course, the reason why a lot of us would support, comprehensive privacy legislation to actually try to harmonize a rather balkanized system that exists right now in the US.
Yeah.
Go ahead, Jay.
Yeah, I would just build on something Dan just mentioned. Trade-offs. There are fundamental trade-offs that we're talking about here, whether it's AI and data sharing, or whether it's authentication, and that's the burden. The burden we're placing on individuals. The cost, cost and burden is about the same thing. But the benefit, the compliance benefit, Filippo mentioned, yes, we're all in favor of cracking down on tax evasion, but that comes at a cost. And then the privacy concerns, right? I mean, you can do a lot with data, but in a way, that's yet another cost. And frankly, I think this case really highlights a fundamental difference in the U.S. philosophy for tax administration, where we have, we cast a very wide net for information, and then we use it as a tool to, to find, those who are non-compliant, versus the EU privacy laws and principles. And maybe some of the tension there could be alleviated through, negotiation with the data sharing agreements, specifying more clearly what the objectives are. But, it may also involve, revisions to FATCA. And Nina, I know, in the past you've talked about the same country exemption, and that would address, Filippo, the Jennifer or yourself, you have small account, you're living in the country, leave us alone kind of thing. So a lot going on there. As far as, I just want to highlight one last point, and I think everyone on the call is, knows how carefully IRS protects taxpayer data under 6103, and that doesn't fully alleviate privacy concerns, but IRS employees and others who use that data, do go through great lengths to protect that data.
So this is really terrific. And I mean, I think these are the kinds of things that we need to discuss as we go forward. And I myself am concerned, and Don, you brought this up, that the IRS has this Inflation Reduction Act funding. And Jay, you mentioned, that none of us want the IRS to just start hiring people and say, go mess around with this data. The need to bring people in that are experts. And to me, it's not just data scientists, but also data ethicists and privacy experts that you're bringing in a team of people to think about these things and to really think philosophically about how you're using data. But Dan, I'd like you to talk about your experience with doing the study that you did, because part of it, when I was reading your study, I was like, well, first of all, you couldn't get access to the actual selection model, but you had a lot of access to data and information. So if you could talk about that as maybe a model of how to do a government academia study that really was groundbreaking, is groundbreaking, and talk about some of the results that you saw, but really how you did this.
Well, thank you for the kind words, Nina. So the way this study kind of got off the ground is that we at the Stanford Reg Lab were part of a kind of working group to really think about the redesign of the National Research Program. That's the program that historically has taken a stratified random sample of taxpayers and then tried to sort of build audit selection streams and estimate the tax gap based on that data. And this was about 3 years ago, and there was a fair bit of thinking about the potential to move the agency to actually learn more from the data that it already had using forms of AI and machine learning. But everybody at that point in time also recognized the real risks of doing so. And so our team both helped with the machine learning components, but also really built out the sort of safeguards to understand demographic or potential demographic disparities. This was, of course, a challenge because the IRS does not observe race and ethnicity on the Form 1040, and under the Privacy Act of 1974 has been restricted from sort of direct record linkage unless for very specified purposes to like census reports. And so we built out a framework and really a methodology of how to do this. And essentially the methodology guesses at what individuals would have reported their race and ethnicity on their census form based on name and address information. And what we found in the study is that Black taxpayers are audited at 3 to 5 times the rate of non-Black taxpayers, and that this difference in the audit rate does not appear to come from differences in underreporting between the demographic groups. The report goes in and studies sort of extensively what could be going on, with the big caveat that, as you noted, Nina, we did not have access to the actual audit selection mechanisms. And what we sort of suggest in the report is that really it's number one, potentially a focus on refundable credits. And number two, if you have models that really just identify whether or not there's any form of underreporting, regardless of the amount of underreporting, those are two types of models that can really generate more of this kind of disparity. Let me just say two things sort of just and open it up for discussion. But I think what's really notable to me about this study is that number one, that this is about disparities in existing legacy audit selection mechanisms. It was not about the transition to any kind of fancy AI. It was really in transitioning to sort of the prototyping of AI systems that really led us to uncover these disparities in existing systems. And then number two, related to this really interesting discussion about the trade-offs with privacy policy, as I had noted, this is a pervasive challenge across the federal administrative state to implement the racial justice executive order and the equity impact assessments because of the challenges in actually even knowing what the demographic attributes of claimants and individuals might be. So happy to discuss any other elements of it, but I think it relates really in an interesting way to some of the tensions that Filippo had noted.
Well, when you the IRS is so proud of saying that they don't know the race of individuals, and so their actions cannot be racially motivated. And it's sort of like, well, that's almost immaterial because the effects can show racial disparity. But then the solution is, do you want people to fill in their racial, status on their tax returns? And the fear is, well, what will the IRS do with that knowledge? It's just really challenging.
Yeah, it's worth noting the context, right? That we have this 10 plus year period of really significant funding declines for the IRS that the IRA funding is really, in a sense, meant to address. And what happens during this period is that the audit rate at the in high income buckets drops precipitously, because it's sort of examiners that are really capable of conducting more complex audits that leave or aren't kind of replaced. And what stays constant really is the kind of audit rate for EITC claimants. And that is part of the kind of structural thing that happened over this period of funding.
Can I, Dan, from the outside looking into the US, we're all following clearly the discussion about the budget ceiling, and we see that based on what you said about the 1974 Act and the sectorial acts, which are relevant for our litigation as well, it seems that in the private sector, where with trillion-dollar companies are able to harvest our data and potentially do whatever they want. You might have heard about the 1.2 billion euros fine imposed on Meta 2 days, which is like a parking ticket for them. And on the other hand, you've got the government, which is some very stringent data protection, apparently, we argue something different, regulation, but they haven't got money, and the ceiling, the debt ceiling, shows that there is no money, and so it's really difficult for government, who is actually got power over us, to it's different. If I fight against Facebook, it's a lovely fight, but if I fight against the government, is the state against me?
Yeah,
so it's very interesting.
Yeah, I think particularly in the technology, I think this relates a little bit to, Don, what you had noted earlier in terms of the real challenges of building up that capacity within government when there's a huge pay scale differential, and how to actually bring people into, because you need that technical talent to actually build these things out in responsible sort of ways. The other thing I'll just return to, Nina, is you had asked, what's the remedy here? And I think this has been a real challenge across agencies. Do you try to pursue record linkage? Do you try to go through the Paperwork Reduction Act to amend your forms and go through the notice and comment process and have people report? That raises all sorts of concerns of whether taxpayers would worry about how that data is being used. I actually do think that being able to figure out how to enable record linkage for purposes of disparity assessments by a unit that is separate from the enforcement unit is a potential path forward. So if we had Treasury co-authors on this study, and they were working out of OTA, and essentially the study was sort of separate, and the whatever imputations we had would not ever be able to be used by an enforcement official. And I think that's an important, separation of functions that can protect taxpayers, and also, help taxpayers understand that this isn't, this is for purposes of monitoring disparities, not for purposes of any enforcement activity.
Well, the other thing about that is, you can do, the IRS has all this data on taxpayers, and you can do surveys of taxpayers. And in those surveys, ask the race ethnicity question. And the federal government has a race and ethnicity question, some standard questions. They're revising it, the Census Bureau is. And I actually encourage anyone who's interested. Earlier in April, I believe it was, the Census Bureau, they had published their revision to what they were going to ask as the question out for public comment. And they held 2 virtual public forums where anybody at all could have 2 minutes to talk about what they thought was the right choice. And it was some of the most intelligent and interesting discussion from just normal people and some academics, but it was just fascinating to hear people think about the collection of data on race and how you would categorize people. But the IRS has never asked the race or ethnicity question because it is so afraid of what people will say when it asks that. Now, the Center for Taxpayer Rights is working with the Taxpayer Advocate Service on a survey that we're doing with taxpayers who have received the earned income credit, received COVID benefits, things like that through the tax agency. And for the first time, we will ask the race and ethnicity question. And part of the population is going to be taxpayers who went through the math error process or went through an audit of these benefits and had them denied. And so we'll be able, we're going to keep collecting the data until we have a population of responses that reflects the United States population so that we can maybe make some conclusions on what's happening there. And I think if you can get the IRS to do that, then you could do that at least through surveys to figure out what's the impact of different procedures and processes on different groups of taxpayers.
Yeah, I think that's. Oh, go ahead, Jay.
I just wanted to jump in, and as you're probably aware, we did a couple reports last year looking at some of the disparities based on race, ethnicity, and sex. And we did make a recommendation to Congress to look at Title 13 and Title 26 and consider revising or changing to facilitate some additional interagency data sharing that would allow some of this really important work to be possible, frankly. And related to that, we also made a recommendation to Treasury to evaluate the feasibility of alternative methods like Dan was speaking to, or surveys that you just described. And I would put forward that it may be more of Treasury's role to take this on, and let IRS focus on tax administration, because the issues that we're talking about really are more fundamental. It's about tax policy and the implications of what the Congress has put out there, and what IRS has to work with, based on the tax law. Second, I just wanted to revisit a previous discussion about the bias question. Back in the wake of the Lois Lerner scandal, GAO did a body of work looking at exam selection, collection selection, and we had a number of recommendations. We didn't find any explicit bias, but one theme that we did hear, and I think it's so important to pay attention to it. And again, Dan, you talked about that you weren't looking at new AI systems. Well, neither were we. We were looking at the existing legacy algorithms and whatnot that IRS was using. And there was a perception or a strong belief that, GAO, why are you looking at these computer models and algorithms? Of course they're fair, because the computers are doing it. And we were like, no, but you have to go back and look at the quality of the data that's going in, what data are you feeding into it? And, so I think there's too much of trust in the technology, particularly, maybe people don't fully understand that, still to some extent what you put in affects what you get out. And, so it's not a new issue, but a very important issue, whether we're talking about political beliefs, religion, race, ethnicity, you name it. It's fundamental.
It's such an important point, Jay, and I think goes back to, what Dawn, you were saying about the necessity of having a human in the loop. I'm reminded a little bit of what the Securities and Exchange Commission did, as it had a kind of AI innovation unit. And one of the really sort of interesting accounts coming out of the SEC was that while they had really interesting forms of machine learning to use natural language processing to sift through filings with the SEC to spot signs for insider trading, it was actually the line level prosecutors that pushed back against the engineers and said, hey, I don't care about your risk score. I care about what I should be looking at because ultimately I have to defend this to a judge. And that's really the form of accountability that we're looking for, is to both have line level agents understand what systems they're using and understand where they might be going wrong, and to push the technology forward in a way that it can really be responsibly integrated. Maybe to return, Nina, to your really important suggestion of the mechanisms to fulfill this by survey. I think that's a really important potential avenue. And Karen Orvis, the chief statistician of the United States, it's a really, I agree, interesting proceeding to really update based on the 1997 data standard, the categories that the federal government employs. The one interesting thing I will note about this is that between any of these options, whether to change the 1040, whether to try to pursue linkage and get a statutory change, as Jay, you noted, or to do this through survey or to do imputation, all of them involve interesting trade-offs that I think we really need to study. And just to use the survey one as an example, Nina, one of the, as you know, the OMB proceeding is really trying to push towards what folks have called data disaggregation. Within the Asian American community, for instance, it's long been a push that, it's this big omnibus, category, and there are real differences within the Asian American community for, different subgroups that can be masked if you just report, one kind of omnibus category. And that's one of the kind of limitations that then shows up with a survey, because unless you use some prior knowledge as to where different subcommunities might be located and how to reach out to them, the survey has to get really, really large to be able to assess demographic disparities, for instance, between Cambodian Americans versus Japanese Americans and the like. And so that's why, in the end, I don't think there is a single purpose thing that's going to fulfill all of this. I think we probably need to be assessing the costs and benefits of each of these different approaches to doing these kinds of disparity assessments.
It just listening was just so fascinating, and I learned so much. I want to come back to this point about the human being in the process, because Filippo, correct me if I'm wrong, but whether it's in the GDPR, isn't it, that you can't make a decision that you're going to do essentially some kind of action on without you can't rely solely on a machine? Or is that under the European?
No, there are provisions about research through harvesting of data. You need to be particularly careful when, for example, you're trying to further medical research with anonymized data. There's all about that. What does anonymized really mean? Because it may be very well anonymized to you, but if you look at the population of this online seminar, if we take all the anonymized people with a funny accent, then we know that I'm the one, and so you've got that. If I may make a point about the human element, I think it is critical. My concern in relation to the campaign, in relation to Jenny's claim, it's the lack of human element, not only in the administration of taxation, but actually, in a way, the absence of human debate at legislative level. Because when we know that in the US, in Europe, increasingly there is a bipolar system. Yeah, you got yes and no, and you can't have any bipartisan law of anything. And actually, when you got a bipartisan consensus, you need to start getting concerned, because it means that something is not really working in a debate. And FATCA, people were just concentrating on the objective, go get them. And therefore, there wasn't any human debate. And so I see this FATCA legislation as a massive, like ChatGPT would said, we need to have one result and one result only, go get them. And so I sort of despair about at the poor level of human debate around tax legislation now in the US. I'm just an observer, but also at OECD level with all this stuff that is coming out of Europe, DAC 6, BEPS, OECD. It's becoming like, and lawyers are becoming overwhelmed because it's nearly like becoming a programming. You're looking at so many acronyms that's trying to make sense of legislation nowadays. It's like going through the codes, and nobody is able to keep, in a way, the overview. And I think that also at advisors level, there is a increasing problem with the level of human input in advice. We just, regurgitate whatever the coding comes out from whatever complex act. Sorry, it's digressing a bit.
Yeah, but I also think, to that point about FATCA and the one-sidedness of it, I mean, the hearings were, compelling. But at the same time, I mean, I had a conversation with, senior people in Treasury who were involved in the drafting, and they've told me in retrospect, they never thought at all about accidental citizens. They never thought at all about the country of Canada, which I keep saying, hello, there are lots of people there that, are affected by this. And it just didn't come up because what they were thinking about was what they were hearing in the 11 hearings, et cetera, which were compelling.
And we got the same. We got the same debate in Europe, and I know you got the Corporate Transparency Act, but we've got the debate, and I was involved in that litigation as well, and it was one about public registers of beneficial ownership. And the idea in Europe was that it was a UK idea that you must have in a publicly available online anyone who owns more than 25% of a company, not just kept by the federal government, but online. And that again was Paradise Papers. I despair about legislation being built around headlines. Yes. And you can imagine, we said, why are you doing that? Oh, to fight tax evasion. But what if you have a company that provides products to say the Ukraine? If anyone out there can find out who's behind the company, there must be a legitimate interest about keeping your information private. And anytime I tried to articulate that one, and then we had to go to court, people said, but then you are for secrecy. No. And so there is a complete breakdown in human debate and democracy in a way. There's a democratic gap because you have a fantastic circus to propel a argument, and there is a complete lack on the other side of the debate.
Well, Don, you've been quiet for a while, so I'm going to let you start with, are there any closing thoughts that you want to share, having had this discussion?
Yeah, it's a fascinating discussion, and a couple of things that I took from it. I talked about the human element, but I think my point was more on the back end. So I appreciate the comments about, and really, I think what we're all talking about is the human element is necessary at all phases, right? It's at the initial phase, and I too am not an AI and data expert, but I have to admit, Nina, I never heard the term data ethicist, which I think demonstrates, and I would imagine there's many people in the IRS that haven't, which probably demonstrates the need for that type of position. And I also think that some type of independent body that could help guide the data analytics. I wouldn't have been opposed to it when I was at the IRS. I would just want to do something. But I think that my real takeaway is it's not just at the end, but you really need that human, you need the debate, the intervention, multiple positions, that diversity of thought and position, and not just career IRS employees to really make a robust, to really advance it in a robust way for the IRS.
Mm-hmm. Jay, any closing thoughts?
Oh, it's hard to follow Don on that one, but I would just underscore the need for new talent, new skills at the IRS. I mean, we mentioned examples where, using conventional computing, they're still trying to catch up on that front, and AI or machine learning is, a real leap. And, the IRS is going to need help to make sure they implement it correctly, first of all, understand it, and then implement and monitor it, effectively, to guard against all the ills and evils that we've been talking about in the last 15 or 20 minutes or so. I mean, it's a key and it's fundamental as we move forward. So I'll end on that.
Filippo, you want to say anything? And we'll end with Dan. So Filippo, any closing comments?
Watch this space.
Great, love it. Dan, you get to follow that up.
That's hard to follow, but I'll say that this is a time of tremendous opportunity at this particular moment, with the IRA funding coming in and with what we're seeing is possible with emerging technology. Agencies that have really done this well, like HHS and the VA, I think have done at least 3 things to manage this transition. Number 1, come up with a strategic plan of how to incorporate this technology. Number 2, figure out how to bring in the technical talent through not just hiring FTEs, but things like academic partnerships and the like, and giving people a sense of mission. The National Security Commission on AI had a chapter on the federal workforce, and they said, look, it's not just the salary scales, it's also that too often there's the perception that when you're kind of a technical person coming into government, you're not given meaningful things to work on. And so being able to figure out how to have that kind of strategic plan and give people a sense of mission and involvement, I think is going to be important. And then third, really having the right oversight mechanisms that involve both the technical experts and the domain experts to ensure that this innovation happens responsibly, I think is a kind of critical element to avoid the kinds of risks that we've articulated through this discussion.
Well, this has just been an incredible discussion, and I'm so grateful to you all for being here. I want to tell everyone that you need to tune in on Thursday, because we will continue this with part 2. And on Thursday, we will have folks talking about some practical applications using automated legal guidance and some of the trade-offs on that. We will have more of a discussion about just artificial intelligence in federal agencies. And we will also have an actual data scientist, Toon Calders, who is at Digitax in Antwerp, in Belgium. And he really has been doing a lot of work in trying to identify, bias in learning data that is training these systems, and how you can ferret out some of that. And I think that just carries some of the points that we've been making here into another discussion on some other issues. So thank you all for being here, and everyone, thank you for attending. And this was a great discussion. Thank you.
Thank you very much. Bye.
Thank you.
Bye.
Take care.
Yeah.